So, what are patent claims? What is patent disclosure? And what's the difference? What does all that mean? It can be very confusing when you're working on your first patent. You have an idea, you go to a patent lawyer, they start throwing a lot of jargon at you. You get these documents that you don't know what you're looking at. And so my objective with this video is to just help demystify some of that so you can understand how these things work and how to look at them. The most of the patent, when you get the application or you look at a granted patent, most of what you're looking at is there's the words at the beginning, then there's some drawings, and then there are these numbered paragraphs at the end, which we call the claims. So that's kind of the three main parts. The words that are before the drawings and other than the claims, that's the patent disclosure. And the function of that, there's really a couple of really important things. For one thing, there's that background of the invention section. Generally, you want that to be real short. Don't go crazy on the background of the invention. There's lots of technical reasons I won't get into, but the point is that that's just setting the stage. That's not the important part. That's not about your invention. Inventors love to sort of delve deeply into that because it speaks to the problem that you're trying to solve and why your thing is so much better. And that's what, in my experience, inventors are, for obvious reasons, fixated on. But from the point of view of your patent, that is actually the actual document. That's the least important part, or one of the least important parts. The disclosure, the function of the disclosure, all of the words that come after that, before the drawings, that is really important. You want to make sure that your disclosure is detailed enough or has enough in it. In most cases, you could have a special strategy. There's everyone's different, and we always start with what is your particular strategy. But in most cases where you're looking to patent something, you want to have enough disclosure that you create opportunities for the future, both opportunities for future patent applications that you can get benefit of priority if you have that disclosure in there. And also opportunities for fallback positions, for supporting claims you may need, all kinds of reasons why having adequate disclosure is important if you're going to set yourself up for success. And then the claims part, then you'll have the drawings. The drawings, there's all kinds of technical reasons about the drawings. Please don't do the drawings yourself or have your draftsman do the drawings unless they're a patent draftsman, because it will just cost you a lot more and take a lot more time. Let the patent law firm or the patent lawyer or the patent draftsman do the drawings. Most patent lawyers, to be fair, do not do drawings. They work with draftsmen. And then the claims part. The claims are the working part. That's the part that's getting examined. That's the part that actually describes the coverage, the protection that you actually have when the patent gets granted. When you file your application, those are potential claims. That's potential coverage. And then in the course of going back and forth with the patent office, which you should be expecting and want some pushback from the patent office, those claims will get modified here and there. Their new claims could get added, etc. And the point of the claims, that is when your patent is granted, the claims describe the boundaries of your property. And that's very important. That's the part that gets enforced. And so, and the purpose of the pushback with the patent office is to make sure that your claims do not read into the prior art. It's kind of like if you're putting up fences, you have a surveyor out there to see, here's the boundary of your neighbor's yard, and you want your fence to be right up on that boundary. So this is the purpose of that patent prosecution. And the way we look at claims is we want to make sure they're broad enough that they're going right up against the fence of all your prior art, so there's no design around room. And that gets to the question, how do I know, what prevents someone else from just copying my idea, just changing a little bit. I think sometimes there's a perception that if it's not in the drawings or specifically described, it's not covered. That's not the case. That's because most people are looking at the disclosure thinking that is, or the drawings and thinking that's the patent. That's not what's patented. What's patented is in the claims, and the whole objective is for those claims to be broad enough that they will cover you as much as they can against the boundaries of the prior art. That way someone either is infringing someone else's patent or they're infringing your patent. There's no room to get around it. So I hope that was helpful. Catherine Cavella, IP Works Law.